Good morning. Okay, so we are leaving behind our discussion of the choice of law, but it will come back. It will be on exams. So we have a midterm in about 3 weeks-ish, 3.5 weeks. And then, of course, at the end of the semester, you'll have a final, and you can expect to see choice of law questions on both of those. I want to draw your attention to, at the end of the Erie chapter, there are 15 review questions. We're not going to cover those in class, in part because some of those look to me like they might be pretty good exam questions. And boy, makes my life a lot easier when someone else writes the exam question for me. So I point that to you as an opportunity for you to continue to review the choice of law principles that we've covered in this class. We're now going to move on to talking about the other type of jurisdiction that federal courts exercise, that courts in general exercise, which is personal jurisdiction. I am going to implement a small change in how we handle cold calling, in that I was starting to get the impression that, the cold calls were not being equitably distributed, in the sense that sort of setting aside whether folks were passing or not, that there were folks who were getting called on in every class, and there were folks who were getting called on only once in a great while. So what I'm going to do now is I have chosen one of you at random to be the starting the starting victim. And then I am going to proceed down the roster in alphabetical order. And that's how we're going to handle every day. So if I come in and the person who's right after you in the alphabetical list is the first call, then maybe you're off the hook. Maybe I won't get to you. But you can't know that until you show up. So with that, Ms. Kellum, you're first up today. So explain to me using no legal terminology. So think about it in terms of explaining it to your grandmother, or if your grandmother's a lawyer, your 5-year-old cousin. Why Francine might think that the result in the hypothetical at the beginning of the chapter is unjust.
Francine would think it was unjust because the company initiated a lawsuit against her without her knowledge, instead of just trying to call her.
Okay, so that's one thing, right? So now let's sort of translate that into legal terminology. What is it that Francine would want in order to feel better about the result? Right. Okay. So what else would she want? Yeah, it's still at you for now.
That's all I had.
Okay. Ms. Kearns, can you help us out? What else would she want?
I would like to not be brought under a fake trip to Florida.
Why not? What does that feel like to you?
Like a lie and like false pretenses, like she thought she won something and it was just better to be.
And what would that? How would that feel to you? Like, how would your 5-year-old cousin react to that?
Not happy.
But what would they call it?
Not fair.
Right. Okay. Think about it like this. This is I think maybe a similar, maybe you can see the parallels here. Is there anybody in here, raise your hand if you did not go to a university in Kansas for your bachelor's degree? Okay. Keep your hands up. Keep your hands up. Of those of you who have your hands up, drop your hands if you grew up in Kansas. Okay. Ms. Borgerding, where did you grow up?
Stillwater, Oklahoma.
Okay, so let us suppose that the dean of the law school at the University of Oklahoma were to walk into this classroom right now and say, Ms. Borgerding, you are expelled from the Washburn University School of Law because of your violations of the University of Oklahoma's Code of Academic Conduct. And do you feel like that is an appropriate outcome in this?
Say no at first because I went to Oklahoma State and OU.
Okay, but Oklahoma State doesn't have a law school. So
They don't have any control over me anymore
why not?
because I graduated and I don't go there. I left.
Okay. So, but were you ever enrolled at the University of Oklahoma School of Law? Or College of Law, I think is what it's referred to. Were you? No, I'm asking in your real life, were you ever enrolled at? Okay, so was it even possible for you to violate the University of Oklahoma College of Law's Code of Academic Conduct? Right. So this is what is happening in this hypothetical, is that the state of Florida is reaching out and demanding that Francine comply with its laws when she was never required to comply with them in the first place. Okay? So this, I think, sort of drives home the overriding characteristics, the things that we are concerned with in discussing personal jurisdiction, which is we're concerned with notice to the defendant, and we are concerned with fairness to the defendant. We're going to keep coming back to these things over and over and over again. Okay? So, Mr. Long, if you could do me a favor and draw on the text of Rule 4 to explain how we can use those rules to address the unjustness in the hypothetical.
So 4A would have provided a notice of failure to appear. That would have put her on notice. 4B would apply because the plaintiff would have had an official summons to serve on the defendant. 4C would apply because process of proper service would have been completed and would have informed Francine. And D would have applied to the plaintiff because they would have proper guidelines on how to serve Francine.
Right. Okay. And I think I don't know that I have anything to add, although I said it a little bit differently. But I think you hit all the points. Yes.
Just how do you pronounce that word?
Which word?
A word.
Ameliorate. Yes. Thank you. I was like, which one? So yeah. Okay. Ameliorate. All right. Excellent. Thank you. Mr. Metz, we have a hypothetical here related to a lawsuit involving an Iowan and a Nebraskan about an auto accident in Nebraska and a lawsuit filed in Hawaii. And there's a statement about amount in controversy and a statement about the basis of subject matter jurisdiction. So my first question is, can we waive the amount in controversy requirement?
No.
Okay?
You can't consent or waive subject matter jurisdiction.
Right. So we learned that back. You guys learned that in 1L. You didn't even learn that in this class, right? So there's no room to waive subject matter jurisdiction. Matter cannot proceed. Okay? So, Mr. Morrell, same fact pattern, but let's change one thing. Let's assume that we've met the subject matter jurisdiction requirements, so we're changing the amount in controversy to get it over that hump. So can they agree to adjudicate their case in Hawaii, even though Hawaii has absolutely no connection to the lawsuit?
Yes, because personal jurisdiction can be waived.
You said it can be waived. Right. So, okay. So I'm going to throw this one out to all of you. Why do you think there's a difference between subject matter jurisdiction and personal jurisdiction on the issue of waivability? There is not really a right answer here, so feel free to sort of speculate. Yes, Mr. Fogg.
I think subject matter jurisdiction is whether the court can hear the claim,
Mhm.
or it's proper for them to do so, whereas personal is just a convenience matter.
I think you're on the right track. I don't know that I agree with the idea that personal jurisdiction is just a convenience matter, and I think we'll talk a little bit more about that as we.
Fairness, and,
No, we'll talk a little bit more about it, but I think you're onto something in talking about the notion of the court's power and where that court's power is coming from as being the key difference, right? So I think there's basically here's sort of what there's folks a lot smarter than me who argue about this a lot more. But basically, subject matter jurisdiction has to do with a court's power that derives from the actions of the sovereign. Okay? Personal jurisdiction is an aspect of the court's power that derives from the actions of the parties. And so it is possible for the parties to take actions that subject themselves to the jurisdiction of the court. But it is not possible for the parties to stand in place of the sovereign and grant the court power to hear claims that the sovereign has not granted them power to hear. Okay? Yes, Mr. Fogg?
I'm trying to balance this idea with theory, right? In the fact that if you can allow plaintiffs to file anywhere they want in federal court based on diversity jurisdiction, like in this case, doesn't that increase forum shopping?
No. This is, plaintiffs cannot file anywhere they want based on diversity, right? So plaintiffs can file anywhere they want if there is complete diversity of parties, right? So that's the sort of initial requirement. However, they can only remain in their chosen forum if the defendants acquiesce. And if the parties are in agreement as to the forum, then that is evidence that there is no forum shopping going on. Because if there was forum shopping, one side or the other would be unhappy with the forum choice. Okay. Yes, Ms. Morrissey.
Does that happen super often?
No. No. This is just a hypothetical to illustrate the difference in waivability. It is not something that I think you can expect to ever see. I take that back. A lot of times, like, breach of contract cases can specify weird fora that don't seem to necessarily have any connection to the breach, right, the alleged breach, but they represent some sort of choice that the parties made in the process of negotiating that contract. And, of course, in, like, consumer or employment contracts, they represent choices made by the powerful corporation, not by the individual. But that's a whole different conversation. Okay. Any more questions? Yes, Mr. Brown.
Do the courts say no to this, like to the Hawaii example?
No. If the parties agree to proceed in in a forum that has zero connection to the claim, courts will go, great, okay. The only question that courts ask is, do we have the power to hear this claim at all? Is there subject matter jurisdiction? And is there a contest over personal jurisdiction? If there's no contest, then the courts go, great, okay, whatever you want. Like, again, because personal jurisdiction is a power derived from the actions of the parties. And so if the parties give the court the power to hear the case, then the court has the power to hear the case. Okay? Ms. Morrissey, back to you. So, the only thing we've discussed this first part. So the only thing I want you to address here is, why is it that personal jurisdiction over a plaintiff is a non-issue?
Well, because the plaintiff is the one that's filing, so it's going to be personal jurisdiction over the plaintiff if they're, I guess, filing.
Right. Exactly right. You sounded uncertain because this question is like, it's simpler than you want it to be. But yeah, if parties acquiesce to the forum to grant personal jurisdiction, then filing in the forum is by definition acquiescence. And so if the plaintiff shows up and files, the court has personal jurisdiction over the plaintiff. Okay. Ms. Schulte, does personal jurisdiction in a federal court over a defendant sometimes depend on whether a state court in the state where the federal court is located would have personal jurisdiction over the defendant?
Yes, because of the language of 4K1A, because it's a four, sometimes, as long as there's not, it can be okay.
Right. So 4K1A provides that service of process confers personal jurisdiction if the equivalent state court would also have personal jurisdiction over the defendant. I do want to point out to you that the remainder of Rule 4K are all mechanisms to establish personal jurisdiction that don't inquire into the jurisdictional reach of a state court. Okay? Mr. Vasquez, apart from a lack of notice, right, we're back at our Francine hypothetical. Apart from a lack of notice, what might render her not subject to the jurisdiction of the federal court in Florida?
I put lack of minimum contacts, purposeful availment, and undue burden.
All right, you're jumping ahead. You're not wrong, but you're jumping ahead. Okay, so of the two things that personal jurisdiction is concerned about, which ones do those fall under? Let's back up and start over, right? What are the two things that personal jurisdiction concerns itself with? Go ahead.
So the context the person has to the state. Notice and fairness.
Right, hey. Okay, so which of those two things does the things that you've raised, which are correct, which of those two categories do they fall into?
Fairness.
I'm sorry?
Fairness.
Right, yes. So remember, everything about service of process has to do with notice. Making sure you are appropriately informed that you are being sued. Which means that, as the court asks, right, apart from a lack of notice, what's missing is fairness. Okay? And Mr. Vasquez has given us a useful word salad of things that help us ensure that Francine is treated fairly. And we're going to unpack what all of those things entail over the course of the rest of the day and into the coming weeks. Okay? So, Mr. Weems, what are the two principles of public law that the Pennoyer case articulates?
The first principle is every state possesses exclusive jurisdiction and sovereignty of the person's property within its territory. And the second principle is no state can exercise direct jurisdiction and authority over persons or property without its territory.
Excellent. Well done. All right. Ms. Akins, how do these two principles reflect limits on the power of the states relative to each other?
The principles recognize that each state has exclusive jurisdiction over people and property within its territory, and no other state can exercise direct jurisdiction over people and property within another state.
Right. Okay. So, I think Ms. Akins has given us a very good formulation here. If you are not quite sure what's going on, I have a different one for you, right? So, we have two states, both alike in dignity, in fair Verona, where we lay our scene. We have two states, right? And according to the first principle of Pennoyer, both of them are exclusive sovereigns within their territory. And one of the things that sovereigns do is they exercise jurisdiction. And so the second principle arises from the fact that if state A can exercise jurisdiction in state B's territory, how can we still call state B an exclusive sovereign? So the second principle follows as a consequence of the first. And the first comes from this old common law conception of sovereignty, right? This Westphalian concept of the state. Okay. Questions so far? Okay. Mr. Albertini, according to Pennoyer, when may a state exercise personal jurisdiction over persons and property outside of its borders?
When the non-citizen is actually in the state, and when the non-citizen owns property within the state.
That second one is correct. However, if the non-citizen is in the state, is the state, let's make this a little more concrete. Let's say that I have gone to KC for the day, right? Go to the zoo, go to dinner, wherever, blah, 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 blah. If a Missouri process server serves me with a lawsuit while I'm in KC, has Missouri exercised jurisdiction outside of its borders?
I don't think so, because you're inside of its borders with her.
Right. So let's go back to what you said at the beginning, right? If the non-citizen is in the state, that is not an exercise of jurisdiction outside the state's borders, right? So you're right about the property question, and we're going to talk more about that in a minute. But let's think more about the first thing that you said, right? So, Ms. Borgerding, can you help us out?
Can you remind me the first thing that he said?
So the first thing that he said, which we've agreed is not correct, is that states can exercise jurisdiction over non-citizens in their borders. And we agree that's not an exercise of jurisdiction outside your borders. The second thing is jurisdiction over property of non-residents. So what does the court in Pennoyer say is the other example of exercising jurisdiction outside of the state's borders?
Oh, the one of two modes, question 9?
Yeah.
Okay.
Or no, question, we're still on 8. We're still on 8. Yep.
Okay, kind of gets the person of the defendant by service of process, so I don't know really, other than property, if they don't have property in the state, then I don't think anything else they could.
Okay. Mr. Brown, can you help us?
I don't think so.
Okay.
I was kind of thinking, the thought I had was way off center, but what if the states had like an agreement between the two? I don't know.
But would that be, if you have an interstate compact, is that an exercise of jurisdiction outside your borders, or is that an agreement to let you treat the other state as if it's in your borders? Right? So, let me ask you guys this, okay? Yes, Mr. Brown, sorry.
Is it the contracts then?
Okay, what about it? Say more.
If you contract in one state, if the particular terms and conditions of the contract are made in one state and they apply that state's laws, then if you're exercising the contract outside of the borders, then those state laws can apply.
Exactly right. So these are the examples that the Pennoyer Court gives. You should not assume that these are exclusive examples, but these are the examples that we have, right? We have, as Mr. Brown points out, a contract that was executed in one state and is enforceable in a different one, okay? So Mr. Brown points out the contract for work that is to be performed away from the site of execution. Also, contracts can have choice of law provisions. And then, as Mr. Albertini points out, there is an issue related to exercising jurisdiction over property. Okay? All right. There's a fairly lengthy passage that I think is useful here. But as contracts made in one state may be enforceable only in another state, and property may be held by non-residents, the exercise of the jurisdiction which every state is admitted to possess over persons and property within its own territory will often affect persons and property without it. Okay, so there's more sort of following it, but that I think is the key language. Okay? Ms. Coolidge. Now, walk us through the two modes that Pennoyer recognizes as ways to acquire personal jurisdiction.
Jurisdiction achieved through the service of process,
And how would we describe that type of jurisdiction? What term would we use to say, this is jurisdiction that relates to the service of process? Let me put it this way. Let me ask you this, okay? So, through the service of process, what physical thing does the court acquire jurisdiction over? Yep. The person, right? We are, in fact, physical things, right? We inhabit meat suits. So we are, in fact, things as well as people. And so that's one type of jurisdiction. And if you were a pretentious asshole judge in 1877 who wanted to sound really smart, what might you do to describe jurisdiction over the person? Might you use a different language? Okay, what would you say in Latin, Ms. Jackson? Right. All right. Ms. Coolidge, what is the other mode of jurisdiction?
Because I'm taking this one, I have taking an action such as a tax claim against property.
Okay. Well, you've done well, and you say you're confused, so we'll move on. It's not a big deal. You've done great. Okay. So, Mr. Devon, what's the other? We've got in personam. What's the other mode of personal jurisdiction?
Well, it's a procedure against the property of the defendant.
Okay. That's fair. Yes, Mr. Fogg? In rem, right? Or in rem if you correctly admit that we don't know how to pronounce Latin, and so we might as well just say it like it's English. So in rem or in rem, and this comes from the Latin term res, okay, which means thing. So you remember from torts, res ipsa loquitur. Anybody remember what that means? The thing speaks for itself. Right? So yeah, in personam jurisdiction, Ms. Coolidge is correct. That requires service of process. In 1877, that requires actual physical presence, because you can't serve someone from, over yonder. In rem jurisdiction is jurisdiction over some piece of property, requires that property to be the subject of litigation. If you are bored and you want to entertain yourself and you have a very low bar for what constitutes entertaining, in rem jurisdiction cases sometimes have very funny case names. This is the one that came to my hand, but I'm thinking of the United States versus 420,000 ping pong balls, which is, I may have gotten the number wrong, but that's a real case. And then there's quasi-in rem jurisdiction, which we're not going to talk about right now. We're going to talk about it a little bit more when we get to the Schaefer case, okay? But for now, you have a definition, and that's all we have to do at this point. All right? Moving on. Mr. Fogg, explain to me what changed between 1877 and 1945 that prompts the International Shoe Court to offer us this justification for the move that it's making. I'm sorry? I mean, fine, but not helpful.
Well, transportation, modes of transportation, modes of communication, the United States Postal Service, the telephones, rail, freeways, even we're getting close to that in 1945. We have cars, not just horses and goats. Like, literally the expansion of everything, which means that the court had to evolve its thinking as far as territory, because you could literally go between 5 states in one day. And
I don't know that you could quite manage 5 states in one day. Maybe in the Northeast in 1945. This is still pre-interstate highway system, and so like
post World War II, which means with air travel.
that, yes, and that actually that became an issue in a case that you guys did not read. My 1L Civ Pro course spent a lot of time in personal jurisdiction, a lot more time than we're going to spend. And we read a case in post-Pennoyer, pre-international shoe, involving someone who was taking a cross-country flight and had been sued, unbeknownst to them, in a state that the flight was passing over. And the process server bought a ticket on the flight, asked the flight attendant to let them know when we crossed into the given state. I don't remember which state it was. And when that happened, got up, walked to the all unknowing defendant, and served them with process. And the court rules that this is a valid exercise of personal jurisdiction because states have jurisdiction over all of their territory and all of the ground underneath it and all of the sky above it. And so when the plane was passing through the forum state, the airspace of the forum state, the defendant was present in the state for the purposes of service and for the purposes of personal jurisdiction. That case is part of why we move in the direction of international shoe, right? So, Mr. Fogg, I'm gonna give you sort of a concrete hypothetical, but I think you're right about sort of the issue here, Rich, is, so in 1877, let's suppose that you wanted to get from Dodge City to KCMO, right? About how long do you think that trip would take you?
Depending on weather, it could be up to 3 weeks.
Right, okay? And if you lived in Dodge City, but you needed to hire a lawyer in Kansas City, about how hard would you think that would be? Right, okay? So now let's fast forward, jump in our time machines, fast forward to 1945. How long would that same trip take?
5 hours, 6 hours maybe.
I think that's optimistic, but certainly it's a day trip, right? At most 2 days. And how hard would it be living in Dodge City to find a lawyer in Kansas City?
Very simple.
I mean, it is not as simple as it would be in 2023, but like,
We have telephones.
right. You can call people, you can find listings of lawyers. It may take you a few days or a week to find somebody, but you don't have to travel just to hire a lawyer, okay? So, is it burdensome in the same way to require you to travel to another state in 1945 that it would have been burdensome to require that of you in 1877?
Yeah, I mean, I think 1877 would be almost impossible.
I mean, not impossible, but
Very unfair.
right. Okay. So, thank you, Mr. Fogg. Ms. Hardy, please do me a favor and describe International Shoe, the corporation. Not the case, the corporation.
The International Shoe Corporation is a business entity that is located in Delaware with its principal office in St. Louis, Missouri, and they process their invoices and different things in Missouri, but they have salesmen who live or conduct business in Washington.
Okay, so what business are they engaged in? Sure, right? And is there, you may have said this and I missed it, is there a factory in Washington State?
No.
Right, okay. So there are a couple of things that you said that I think are going to be relevant for the next question, but you hit all the high points, right? So this is a Delaware corporation, and we call them a Delaware corporation because that's where they're incorporated. But in terms of where they're located, their principal place of business, you're correct that that's in St. Louis. They're engaged in the business of shoe manufacturing, and their factory is, well, it's in St. Louis, right? But for the purposes of this case, all we care about is that it's not in Washington. All right? So thank you, Ms. Hardy. Mr. Werter, describe the contacts that International Shoe has with Washington State.
They had several salesmen, I think it was 13 or something like that, who resided in Washington, and then they displayed shoe samples to prospective purchasers within the state of Washington, and then the company would also like rent out rooms for periods of time to display those shoes.
And are these salesmen paid a salary?
I'm not sure, was it commission-based?
That is, in fact, what the court says, right? As we know, whether the court gets the facts right, not always something we can trust, but for the purposes of understanding the case, we can, as long as the court is relying on the facts that it recites, we can treat them as given. So they're paid on commission. What equipment do these salesmen carry?
I'm pretty sure it was just the samples of shoes that they were given.
Right. And do they accept money?
No. So if they were to place an order, they would send their order to the principal place of business in Missouri, and then the corporation would ship the shoes that were stocked outside of Washington State.
Do the salesmen even have the authority to contract on behalf of the company?
No.
So all they can do is essentially like solicit offers to buy,
Yes.
right? And then the company decides whether they're going to accept any given offer. Okay? And who pays for the transport of the shoes on accepted orders?
I'm not sure.
I'm sorry? Do the salesmen pay? Is that a normal? Is that normal? Like, is this a Mary Kay operation? Who pays for the transport of the shoes? Right. Think back to contracts. This is a term called free on board, which means once it leaves the seller's place of business, it belongs to the buyer. The buyer is responsible for the costs of transport. The buyer carries the risk of failure to deliver. Okay? So these are the nature of the contacts that International Shoe has with Washington. So let's just, because this one puzzled me for a second until I thought about it. Why do you think the court makes a point of noting that the buyers pay for the transport of the shoes? Mr. Fogg?
It's because the shoe company is not doing business in Washington. Those people are doing business in Missouri, right?
Right, and that is essentially the reason why this issue is relevant, because it underlies an argument that, as Mr. Fogg says, International Shoe is not doing business in Washington. All of their customers are doing business in Missouri. Okay? All right. Ms. Jackson, we're going to take this in two parts. So why is the state of Washington suing the International Shoe Company?
I said it's basically like tax evasion, the unpaid status towards statutory mandates requiring employment contributions to the state.
Tax evasion, I think, may be an oversell. But you're right about the rest of it. I'm like, characterization, because it's essentially, it's unemployment insurance, right? And, the state is saying you are chargeable for insurance premiums related to these 11 to 13 salesmen, and so we expect you to pay. And the company's going, well, we're not a Washington employer, so we don't have to pay Washington unemployment insurance premiums. So, Ms. Jackson, where was this suit filed?
Washington? I don't have that written down.
Okay. So, which court? State or federal? Okay. Why? So, let's think back to chapter 11. Is the state a resident of the state?
Is the state a resident of the state?
Yep. Is the state of Washington a resident of the state of Washington? On what basis? So, there has to be some sort of legal basis for determining that the state of Washington is a resident of the state of Washington.
I mean, they are the state, they're the sovereign of the state.
But do they reside there? Does the state reside?
Get into some interpretation about that, I guess, but.
I mean, I don't need to. So, states are not residents. States are not citizens. Right? Let's go back to 1332. Right? Open up your rule books, pull out and look at 28 USC 1332. So, what kinds of lawsuits are authorized under 1332? Mr. Johnson. Citizens of different states. What else? Go ahead and.
Citizens of different states in which citizens are subject to a foreign state, a state, and a citizen of another state.
Okay, so we can get there, right? So we have a state and a citizen of a foreign state. But who filed the lawsuit? Do you think the state is ever going to file in federal court? No. So, suit is filed in state court, right? Okay. Yes.
So then what is the basis? You said there has to be a legal basis for a state to sue.
Statute says it,
Okay, so it's
right?
just
Says,
1332.
yeah, a state and a citizen of a foreign state. Yeah. So, yes, Mr. Johnson.
It kind of made it seem like it was like an administrative court. Do you know, or was it just regular Washington?
I don't know. I don't think it matters. So, if a state court of general jurisdiction can hear the case, then presumably a court of limited jurisdiction created for the purpose can also hear it. Okay? All right. So, Ms. Kellum, the two basic issues in personal jurisdiction cases, notice and fairness. How do we have notice satisfied in this case?
So notice was personally served on a sales solicitor in the state of Washington for that copy of the notice that went out to the company's principal place in business.
Right. And there's a reference in the court that, look, the state's not trying to hide the ball here. They clearly wanted you to know that you were being sued. All right? So, Ms. Kearns, what is a special appearance? Yeah, right? So, I sort of didn't expect you to get that one right, but you're right. So, you can see how I sort of I wrote this slide like it's okay. You don't expect to know that one. But yeah, the issue with personal jurisdiction is if you show up in court, you are now present in the forum state and you can be served with process, and now the court has acquired personal jurisdiction over you, right? So prior to the development of the special appearance, defendants who did not believe that the court had jurisdiction over them would either have to acquiesce to that jurisdiction by appearing and defending, or fail to appear, take a default, and then engage in a collateral attack on the judgment. And look, those are hard to win. And so the special appearance is where we all sort of agree that, yes, you're here, but you're not really here. And once we resolve the issue of whether the court has jurisdiction over you, then we can move on to discuss the merits of the case. And if the court doesn't have jurisdiction over you, we don't have to move on to that. Okay? All right. Mr. Long, what is your understanding of capias ad respondendum?
Seems like it's a process, commanding officer to place a person under civil arrest in order to answer a charge.
Right. And so, let's see if we can connect this. You're absolutely right about what it was, right? This is a common law writ that directs the sheriff to go and find a non-appearing defendant and hold them in custody so that we know they're going to show up at the court's next sitting. So let's think back to merry old England, medieval common law. Like, let's look at Robin Hood, right? Sheriff of Nottingham. Can the Sheriff of Nottingham just wander all over England looking for Robin Hood? Where can he go? Nottinghamshire, right? That's fine. Not even the Disney one with the foxes and the bear? And no? Okay. Fair enough. All right. Then we'll let you off the hook. Mr. Metz.
I haven't seen it either.
All right. So you're passing?
If the question is about Robin Hood, then yes.
The question is about personal jurisdiction. Robin Hood is the example.
Okay.
So Sheriff of Nottingham can only travel in Nottinghamshire to try and get his hands on Robin Hood. So if the court in, say, Cornwall, which is a part of England that is very different from Nottinghamshire, were to issue an order to capture Robin Hood, could the Sheriff of Nottingham execute that order in Cornwall, right?
No.
No, because that's not where he's the sheriff, right? So all Robin has to do is he has to get out of Nottingham and he goes to Cornwall or, Yorkshire or, God forbid, Scotland. So yeah, courts could only acquire personal jurisdiction within the geographical space where they could issue valid orders to law enforcement. Okay? So this matters, right? This matters because this is the underlying common law origin of everything that we're doing in this chapter, is that courts can only force you to appear in the jurisdiction where they can issue valid orders to law enforcement. Okay? All right. Mr. Morrell, we have an agreement. We've said earlier that the corporation was given adequate notice of the lawsuit, but we know that's only one component of personal jurisdiction. The other component is fairness. So what is the essence of the corporation's argument that it is unfair to permit a court in Washington state to adjudicate this claim and issue a valid judgment?
The company says that its actions in the state do not amount to having a presence there, and that the state would not have jurisdiction, therefore it's a denial of due process for the state to subject a company to this.
Right. So the defendant is relying on the Pennoyer test. And they say, look, whatever we're doing in Washington, it is not enough for us to be considered present in the state. And so it violates due process for a court in Washington to exercise personal jurisdiction. All right? Mr. Morrell, last thing, and then we'll call it a day, which is What does the Supreme Court have to say about this argument?